right, thank you very much, Amber. While my PowerPoint is opening, there it goes. Let me just do a couple of housekeeping reminders. We are going to be taping this webinar, and the slide deck and the tape will be sent to you, so you can get that. So don't worry, we will be sharing the materials. You can also access the tape of the webinar by going back to ctpleave.org, clicking on our events page and looking at the calendar for today. We will make that video available on that calendar page as well. During the webinar, if you have questions, please use the Q&A function in Zoom. Please do not use the chat function because we're not monitoring the chat function. We use the Q&A function so that we can keep track and make sure that we are able to follow along. The materials do not email well because of all the graphics, so that's why we're not emailing them to the participants right now, but we will have access to them later. All right, let me go ahead and share my screen with the slide deck. And we'll get started. So the goal of this next hour is to provide businesses, employers with information about both FMLA and the Connecticut Paid Leave Act, so you have a better understanding of those two laws and some better understanding of how the programs will be implemented, with a particular focus on what employers' responsibilities are. As I said, we will go through questions, and I've got time at the end to make sure we have time to go through the questions that come in. So my name is Erin Choquette. I am the General Counsel for the Connecticut Paid Leave Authority. I'm an attorney by training, and I've worked for the estate for over 15 years and with the authority basically from the beginning, but officially for the last year. And our agenda for today is to talk a little bit about the paid leave program, just so you know kind of who we are and what we do. And then we'll talk about FMLA, what that means, what is CTPL. And then, as I said, we'll focus on the implementation of the two laws with some resources and time for questions and answers. The Paid Leave Authority. We are a quasi-public agency. We were created by statute to launch the Connecticut Paid Leave Program. So to make sure that employees working in Connecticut have a way of receiving income replacement benefits if they have to stop working because they are sick themselves or they have to care for a sick family member. We've had job protected leave in Connecticut since the 90s, but we have not had a source of income replacement. So people who could not afford to be out of work really were unable to take full advantage of the job protection. And so that's where we fit in. We do think it's important to also be a resource to employers, administrators, healthcare providers, all the people who participate in this process, to make sure that everybody understands what their roles are, what their responsibilities are, and to help them fulfill those responsibilities. At the authority, we do outreach and engagement, like educational opportunities like this webinar, because it's important for people to understand what this program entails and what their rights are. As I said, we're brand new, so we actually had to set up a new program while we were setting up a new agency. So we've been doing that. As a quasi-public agency, we don't have regulations. We have publicly noticed policies. So our board adopts policies after receiving, after giving the public an opportunity to comment. So if you're ever looking for our policies, they are posted in the Connecticut Law Journal for public comments, and then they are adopted by our board. The program runs off of employee contributions. And so by statute, the contributions can be no more than 0.5%. But in the future, if the fund has a nice reserve, we may be able to reduce that amount. And of course, we receive the contributions. There is a process in our statute which allows employers to comply with the paid leave program by offering their employees what we call a private plan. So instead of having the employees contribute to the paid leave program, the employer sets up a private insurance plan or self-insured plan, but they have to get approval from the authority to do that. And so we have a private plan application and approval process, and those plans will be audited by our program. And of course, we administer claims for paid leave benefits. We will be making those income replacement benefit payments to covered employees effective January 1st. We've been doing a lot in the short amount of time that we've been in existence. Our website went live in September of 2020, and employer registration started in November. So as employers, you should all have an account with the Connecticut Paid Leave Authority, because that's the way that the contributions come into us, and that's how we attribute your contributions to the employers. As I mentioned, those contributions began in January of 2021. The ability to apply for private plan as the alternative to the public plan opened in February, and we've been just running at full steam ahead since then. Contributions are due on a quarterly basis. We do have a 1-month grace period at the end of each quarter. So, for example, the third quarter contributions are coming in now, and you will not be late as long as you get them in by the end of October. We will be opening the doors, electronic doors, to receiving applications in December. We'll be making payments starting January, so no payments will be issued before January 1st. But we know that there is a pent-up demand, and there are people who know that they will be out on leave starting in January, and so they can apply to us in December to get ahead of the game. So we'll talk a little bit more about those elements in a few minutes. But first, I really wanted to set the threshold. Who's covered by our program? It's always an important question to answer. And the short answer is almost everybody working in Connecticut is covered by our program. Employers who have one or more people working in Connecticut are considered to be covered employers. This includes nonprofits. This includes domestic or people who hire domestic workers. It includes private sector employers with unionized workforces. So pretty much if you have people working here in Connecticut and you pay them wages and that they are subject to W-2 wages, then they're an employer and they're most likely covered. Sole proprietors and self-employed individuals. So basically people who pay self-employment taxes rather than have paychecks and pay via W-2 are not required to participate, but they are given the opportunity to enroll if they want to. If they do choose to opt in, they have to stay in the plan for at least 3 years. There are some entities that are excluded from the program by statute, and these are basically the same entities that are excluded from participation in Connecticut Fmla. And they're primarily governmental entities, with one exception. So the federal government, we can't tell the federal government what to do. Sorry about that. So we can't make them contribute into our program. The state of Connecticut is excluded except as to our covered public employees. I'll define that in a second. Similarly, municipalities and local or regional boards of education are excluded unless they have covered public employees. And finally, non-public elementary and secondary schools are excluded. Those are the entities that are listed in the Connecticut Paid Leave Act as being excluded, but there are some other laws that we have to take into consideration that exempt other entities. For example, railroad workers are covered by federal law that applies to railroad workers, so they don't participate in our program. Similarly, employees who are engaged in interstate commerce, primarily truckers, interstate trucking, or rail employees who work in Connecticut but live in another state, don't pay income tax in Connecticut, and so they don't pay into our program either. There's a similar law, it's called the Military Family Relief Act, or Military Spouse Relief Act, that says that spouses of active duty military members who opt to continue to pay taxes in their home state instead of where they're currently deployed don't pay taxes where they're currently deployed. So if that's a situation, they wouldn't pay into our program either. And then there's, of course, employees who work for other governments. So if you work for another state or you work for one of the sovereign nations, we are not able to tell other sovereign nations what to do, so they're not participating in our program either. Mentioned, there's something called a covered public employee. So covered public employees do participate in the program. They do remit contributions and will be able to apply for benefits. So non-unionized employees of the state, so managers, appointed officials, legislators, judges, we are all considered covered public employees, so we do contribute to the program and could apply for benefits. Unionized employees of the state are not covered unless they collectively bargain to be included. Right now, employees of municipalities and employees of local or regional boards of education are not covered. But if the unionized employee of the town or board collectively bargain to be included, then everybody comes in, union and non-union. As I mentioned, sole proprietors, self-employed individuals, independent contractors, they're not employees. They are different, completely different under the tax law. So that's how we look to define you. So if you pay self-employment taxes as defined by the IRS, you are not an employee and you are not required to participate, but you can choose to enroll. And your contributions are based on 0.5% of your self-employment earnings. If you are a sole proprietor who also has employees, we consider you to be an employer. So you do have to register and remit the employee's contributions, and then you can decide if you choose to enroll for yourself. If you are someone who, maybe you're the owner or the officer of a company, but you are set up so that you receive a W-2, well, then you're considered to be an employee for purposes of taxes. And so you're an employee for purposes of the Paid Leave Act. Okay, there's no owner exception. It really goes to, are you getting a W-2 or a 1099? If you're a business that contracts with independent contractors and the contractor you've contracted with has enrolled, it's up to them to remit their own contributions. You don't have to do any deduction or remittance in connection with your independent contractors. So what are these contributions that I've been talking about? Well, they're 0.5% of the employee's wages. And when we talk about wages, we're really talking about the employee's FICA wages, the amount of money that you look to when you determine what an employee's FICA obligation is. And the reason we use the FICA number is because our statute says that the contributions are 0.5% up to the Social Security contribution limit, which this year is $142,800. So that Social Security contribution limit is also based on the FICA wages. So to make sure we're complying with that part of the statute, we use the FICA definition. It's coming from the employees. The employers do not pay into the program. But the employers are the ones who are responsible for doing the paychecks, right? So you're issuing the paychecks, you're handling the deductions. So the employer is responsible for taking the deductions and remitting the contributions to the authority on a quarterly basis with some minimal wage information. That money comes into the authority, we validate it, attribute it to the appropriate employer, and the money goes straight into the paid leave trust. This trust is not state funds. They cannot be used for any state purpose, it cannot be swept, it cannot go anywhere except to fund the paid leave program. So that's what we use to pay the benefits and to pay the administration costs. All right, so that's a quick overview about the program. Let's talk about the laws that we're kind of considering when we deal with this program. And the first thing is to really define the acronyms. You'll hear us say FMLA. You'll hear people talk about FMLA. Well, those letters stand for the Family and Medical Leave Act. There's actually a federal FMLA as well as a Connecticut Fmla. Other states also have their own FMLAs, but we're not going to worry about those because they don't apply to us. Both the federal FMLA and the Connecticut Fmla allow eligible employees to take job-protected time away from work. That's what they do. It's job protected leave. Both laws state that the leave is unpaid, but that the employer may adopt policies to provide their employees with income replacement during the leave. So some employers just provide paid leave. It doesn't come out of the employee's accruals. It's just, yep, we're going to keep you on the payroll for X amount of time. I think more employers say, we give you paid time off. We have you earn sick leave. We have you earn vacation time. You can or you will be required to use that time when you're out. It's up to you to determine if you're going to require or permit your employees to use their accruals. The Connecticut Fmla has been in Connecticut since the early 90s, and the federal FMLA has been on the books since the early 90s. There are discussions about changing federal FMLA, but those changes haven't taken effect yet. The changes to Connecticut FMLA were passed in 2019, but they will take effect in January of 2022. So let's talk about those changes because they're pretty significant. We changed the standards for eligibility. We changed the standards, or the law has changed the standards for eligibility, the reasons for leave, as well as sort of who's covered by the programs. So let's talk more specifically. Right now, until the end of this calendar year, Connecticut FMLA applies only to employers with 75 or more employees. In January, it will apply to employers with 1 or more employees. Right now, to be eligible for job protection, the employee has to work for the employer for at least 12 months, and they have to have worked at least 1,000 hours in the 12 months immediately preceding the day that they go out on leave. But in January, that changes, and the ability to take job protected leave will start after 3 months, and there will no longer be an hours worked requirement. The amount of leave changes from 16 weeks in a 24-month period to 12 weeks in a 12-month period. There's something called military caregiver leave, which is leave that an employee takes because they need to care for a family member who is injured on active duty in the military. That is 26 weeks of leave. Under the current FMLA, it's 26 weeks of leave in a 24-month period. It goes to 26 weeks of leave in a 12-month period. Connecticut FMLA will also, starting in January, allow employees to take an additional 2 weeks of leave if they experience incapacitation during pregnancy. So it's an exception to the 12-week rule. There's also an exception to the rule about what employers can require employees to do with their accruals. As I mentioned, both federal and state FMLA say that the employer can permit or require the employees to use their accruals while they're out on leave. But this is going to be changed slightly in January to say you can still permit or require your employees to use their accrued time off, but you can't make them exhaust all of their time because they're out on FMLA. You have to let them hold on to at least 2 weeks to use for other purposes if they want to. All right, so that's FMLA. Then there's CTPL. CTPL stands for Connecticut Paid Leave. It is a different statute. It creates a source of income replacement benefits. It does not provide job protected leave. So when people talk about paid FMLA, paid FML, they're not talking about additional job protection. They're saying this is a source of income for people who are out on leave. With both Connecticut Paid Leave and Connecticut FMLA, there are a specific list of reasons that you can go out on leave and get income replacement. The first is for your own serious health condition. So you need to receive treatment or recover from your own serious health condition, which includes pregnancy as well as serving as an organ or bone marrow donor. It also includes things like having a chronic condition for which you need to see a doctor for treatment at least 2 times a year, having a end-of-life condition for which treatment is not available, but you're receiving palliative care. It also includes situations where, say you have a broken leg or you're undergoing dialysis, so you have repeated treatments. There's a whole list. They're on our website if you're looking to see what the reasons are. But that's medical leave. You could also care for a family member who has one of those serious health conditions, which we call caregiver leave. Then there's the happy reason, the new baby. So you can take leave to bond with a newborn or a newly placed adopted or foster child. It does not have to be a baby. But the idea is to take time to be able to connect emotionally and physically with that new child in the family. And in the cases of adoption and foster care, you can use bonding leave to attend to certain pre-placement activities like going to court or having to travel to get the child. As I mentioned, there's this military caregiver leave. There's also something called qualifying exigency leave, which applies to military families. So if you have a parent, spouse, or child who is being deployed to active duty, your employee can take time off to address things like going to the sending away ceremony or having to make new financial or legal arrangements because you need to get power of attorney, for example, for the person who's deployed. There's a list of 8 reasons that qualify as qualifying exigency leave. And then there's family violence leave. So family violence leave is technically not FMLA. It's its own statute. We've actually had it on the books since 2012. And that statute says that an employee who is directly experiencing family violence can receive up to 12 calendar days of job protected leave to go to counseling, go to court to deal with the family violence situation, to relocate if they need to. So the Family Violence Leave Act is still on the books. And now with the Connecticut Paid Leave Act, the Paid Leave Authority will provide income replacement for those 12 days. Couple of things to know about caregiver leave. If you're used to Connecticut FMLA as it's existed up till now, or federal FMLA, you know that caregiver leave has been limited to caring for your parent or your spouse or a child who's under the age of 18. But as of January 1st, caregiver leave will be expanded and an employee can take leave and receive paid leave benefits for a parent or a spouse, a son or daughter of any age, or a sibling or a grandparent or grandchild. Additionally, an employee could take caregiver leave to care for an individual who's related to the employee by blood or affinity, whose close association the employee shows to be the equivalent of parent, spouse, child, sibling, grandparent, grandchild. So a lot more people that you can take leave to care for now. How do we determine who's related by affinity? Well, it has to be done on a case-by-case basis. The employee has to show that they have a significant personal bond with that person who's the equivalent of a family member. The Connecticut Department of Labor is in the process of adopting regulations to define this, but we know that those regulations are going to say that an employer can require the employee to provide a simple written statement describing the relationship. The employer can't require 10 years worth of photo albums or, blood tests or anything of the sort. It would be a simple written statement. We actually have a related by affinity form that we will be using for our program. It will be on our website, so employers can use that if they want to. But what are the relationships we're talking about? They are family relationships, even if they do not meet the legal definition of family. So, for example, in my own family situation, I had a great aunt who lived 10 minutes down the road. She came to every school event, every holiday. We did her grocery shopping for her. And when she got older, we were the ones who took care of her. And so if she were still alive today and broke her hip again, she did that a lot, I would be able to take caregiver leave for her because she's the equivalent of my grandmother. Similarly, in Connecticut, or another example is the unmarried significant relationship. Connecticut does not recognize common law marriage. So if you are with a person in a spouse-like relationship, but you never actually got married, so think Goldie Hawn and Kurt Russell, Connecticut law would not recognize that as a marriage. They would not be able to take leave to care for each other. Well, that's being changed. And as of January, that unmarried significant other with whom your employee maintains a spouse-like relationship would be considered a covered relationship. So the next two slides are really kind of here just to summarize the three laws that we tend to talk about: federal FMLA, Connecticut FMLA, and Connecticut paid leave. Just really want to kind of make it something you can quickly and easily refer to. So who's eligible? Well, for federal FMLA, if you're an employer with 50 or more employees, you're subject to federal FMLA, and your employees could take job protected leave if they've been employed for at least 12 months and have worked at least 1,250 hours in the 12 months immediately preceding leave. Connecticut FMLA used to have similar requirements, but as of January 1st, the new requirement to be eligible for job protected leave will be to be employed by the employer for at least 3 months. That's it. Paid leave benefits, on the other hand, we don't look at how long you've been employed by any particular employer. Our statute says that we look at how much money the employee has earned. If they've earned at least $2,325 in their highest earning quarter, when we look at the first 4 of the 5 most recently completed quarters, they will be eligible, as long as they are also currently working in Connecticut, or if they're not employed right now, they had been working in Connecticut at some point in the 12 weeks before they applied to us, or they're an enrolled self-employed individual or sole prop. So we look at how much money they have, and we are able to get information about that from the employee, the employer, and Department of Labor. Quick summary of the entitlements. Basically, remember the number 12. 12 weeks in a 12-month period, except 26 weeks for the military caregiver, an extra 2 weeks for incapacity during pregnancy, and those 12 days for income replacement and leave for family violence leave. If a person is eligible for federal FMLA and Connecticut FMLA, and the reason for leave is covered by both federal FMLA and Connecticut FMLA, say it's your own serious health condition, the federal FMLA and Connecticut FMLA will run concurrently, meaning the employee will draw down their entitlement at the same time. If they are in need of income replacement benefits from paid leave during that period of time, the 12 weeks of paid leave benefits will also run concurrently. But if you're not eligible for federal FMLA, but you are eligible for Connecticut, you're not going to touch your federal. If the employer requires the employee to use their accruals before they apply to the paid leave authority for benefits, an employee might start their job protected leave a few weeks before they actually receive any benefits from the authority. So they may not always align 100%. With that, let me just see, we had a question in here about the materials, which I've already addressed. So let's talk about implementing the Paid Leave Act. Let's start with the responsibilities. I think it's always best to kind of understand everybody's roles. When we talk about Paid Leave Act, we're talking about both the contributions and the claims. So contributions. The worker's responsibility is to contribute 0.5% of their wages up to the Social Security limit to the fund. The employer's responsibility is to make sure that we get that money. To do that, they have to register with Connecticut Paid Leave and create an account, deduct those wages, that 0.5% from the employee's wages, and remit that money to the authority. The authority's responsibility is to receive those contributions, process any overpayments or underpayments, and we will be imposing penalties for non-compliance. We made the policy decision this year, for this first year, to really focus on encouraging compliance and helping employers to comply. But starting with next year, employers who do not respond to their responsibility to deduct and remit the contributions will be subject to penalties. One of those penalties is that they may have to take on the responsibility of paying the employee's share. because the employee has no way of giving us the money directly. So if the employer hasn't set that process up, it may become the employer's responsibility to make those payments. With that, let me talk about Connecticut DOL. They don't have a lot of responsibility in connection with the contributions under the Paid Leave Act, but they do have general responsibility under the wage and hour laws, which include the responsibility of approving deductions from employees' paychecks if it's not already explicit in a statute. And so DOL has used that authority this year to help employers who weren't able to get the process of taking the deductions out of paychecks in place in time for January. So up until the end of September, the Connecticut DOL said, employers, you can take extra money out, up to an extra 1%, to just get those contributions made. That period of time has ended. So if you didn't take your deductions starting in January and you didn't use that catch-up period, you either have to ask DOL for specific permission to take extra deductions, or as I said, you may have to take on the responsibility of paying your employee's share and dealing with the potential tax consequences of that. All right, let's talk about the claim side, responsibilities. It's the worker's responsibility to submit their application to us. The employer doesn't do that, the employee does. To do that, they'll create their own account and they'll provide us with documentation to substantiate their reason for leave and the need for benefits. And they have to provide us with information about their absence as well as sources of income. They are required by statute to tell their employer they're applying to us for benefits. You, as the employer, will be asked to complete and submit to us an employment verification form. This is one page or one piece of paper, two-sided. We need to get information about the employee's schedule and if you're providing any income replacement to them, or if you're going to require them or allow them to use their accruals. We may need to work with you to validate absences on occasion. We do need you to tell your employees if you're going to require them to use their paid time off, or if you offer a short-term disability. And so you need to let the employees know what their requirements are, and you need to let us know what you're doing. And as always with all of these laws, you can't discriminate or retaliate against a worker simply because they've applied for their benefits under the law. Now, the Paid Leave Authority has entered into a contract with AFLAC for claims administration. So we'll be working with AFLAC to process these claims, determine eligibility, review the documents, calculate benefits. We'll be monitoring the usage to make sure it's consistent and that they don't exceed their entitlement. If we deny claims, we do have a reconsideration process. We will also be investigating fraud and misrepresentation and imposing penalties as appropriate. If we deny a claim or impose a penalty, the individual could submit an appeal to Connecticut Department of Labor seeking a reconsideration of that decision. So what does this look like? Well, as I said, it starts with the worker submitting the claim. They can either call AFLAC or go online to AFLAC or go to ctpleave.org and say that they want to apply, and we'll redirect them that way. They will submit an application checklist or go through the checklist with the people at AFLAC on the phone, and we'll ask them to provide us with documentation to substantiate the reason for the leave, the length of the leave, and whether they have other jobs or other sources of income. AFLAC will determine eligibility. We're using DOL data primarily to determine if someone has the 2325, but we may need other documentation. We're going to validate that they work for a covered employer or they're an enrolled sole prop or self-employed individual. If someone is not eligible, we'll notify them right away. There is that opportunity to request reconsideration, but we want people to know that as soon as possible. If they are eligible, we'll continue on the process, reviewing the supporting documentation. The type of documentation needed really depends on the reason for the claim. If it's your own serious health condition, we get a medical certificate from your doctor. If there's anything missing, we'll let the applicant know. If we deny the claim, we'll notify the worker why it's denied, give them an opportunity for reconsideration. If we approve the claim, then we go on to the benefit phase. The benefit calculation is used, we take DOL data primarily, but we may need additional information, and we will calculate the benefits. People can take leave on a block basis, which is several days or weeks of leave for one reason. It could be intermittent, which is you've got one reason for leave, but you don't need to be out all the time. You might need to be out one day a week, or you have a condition where you have flare-ups. So you might, if you have a migraine, you might be out down for the count for 12 hours. So, and then there's reduced schedule, which is I'm changing from full-time to part-time. So we need to know what that is so we can determine what your benefits are. We're only going to pay benefits for when you're not working. The benefits will be issued via electronic transfer or a stored value card, which is basically a debit card. Our plan is to issue those benefits every Tuesday, 2 weeks, basically 10 days in arrears. So for example, the benefits for the first week of January, that week runs from January 2nd to January 8th. The benefits would be issued on the 18th. If people tell us in advance that they need the benefits, we can get through all of that documentation ahead of time. If they don't know that they're going to need benefits until they're out of work, then we'll get them the payment as soon as we can validate the reason. And then the benefits are issued every week thereafter. The worker is responsible for notifying us of any changes. If they need more time, they're going back to work early. If it's intermittent leave, they need to let us know when their absences are because those might be unscheduled. Just so you know, the formula for paid leave benefits is in the statute, and it depends on how much the worker earns. If they earn less than or equal to the Connecticut minimum wage multiplied by 40, the base weekly benefit is 95% of their base weekly earnings. The base weekly earnings are calculated by looking at the highest 2 earning quarters in the first 4 of the 5 most recently completed quarters. If someone earns more than 40 times the Connecticut minimum wage, they'll get the 95% of 40 times the Connecticut minimum wage plus 60% of the difference between what they earn and the Connecticut minimum wage multiplied by 40. However, in all circumstances, the total benefit is capped at 60 times the Connecticut minimum wage. So no matter what you earn, can't get more than 60 times the Connecticut minimum wage in benefits. Just like the contribution was capped, the benefits are capped. So I don't know about you, but that's a lot of words. Sometimes when you're talking about math, it's easier to just show the work. So that's what this slide does. So if we're talking about a 13-hour minimum wage, 40 times the Connecticut minimum wage is $520. Person who earns that would get 95% in benefits, so $494. Someone who earns more than the Connecticut minimum wage, we have the 2-step process. 40 times the Connecticut minimum wage plus 60% of the difference between 40 times the Connecticut minimum wage and what they're earning. So worker B in this situation earns a little bit more than the minimum wage, so they're going to get a little bit more in benefits. They'll get $506 a week. We get lots of questions about the intersection of employer-provided PTO and the paid leave benefits. So there are a couple of things to know about how the intersection works. First, our statute specifically says an employee can receive benefits from the employer and the paid leave program at the same time, as long as the total amount does not exceed 100% of their regular wages. So you can definitely get money from both, but it can't exceed 100%. As we've talked about with FMLA, the employer may require or permit the employee to use their accruals as long as you make sure that they have 2 weeks that can be held in reserve. So as an employer, you're entitled to say, hey, I give you these accruals for a reason. I want you to use them. And if you're concerned about your employees stacking up their entitlements, basically using them consecutively as opposed to concurrently, it may be a good idea to say, yeah, I'm going to require you to use your sick leave when you're sick. If you offer short-term disability insurance to your employees, you need to look at your specific policy because the policy terms control what is entitled. Many short-term disability policies say they're the payer of last resort, but not all. So you need to look at that. So that's the background. What does this mean in practice? Well, there are 4 scenarios. The first, the employee doesn't have any PTO. The employer doesn't provide them with any paid time off. So they'll get CTPL benefits for the full amount of time that they're out on leave, assuming they're eligible. So they're out on January 2nd for 3 weeks. They'll get CTPL benefits from January 2nd for the full 3 weeks. Scenario 2. The worker has paid time off from their employer, and the employer requires or allows them to use it. And it's more than enough to cover the 3 weeks that they need to be out for their serious health condition or caregiver or what have you. So they're getting their regular wages for the full time they're out on leave. They're not even applying to the paid leave authority because they don't need money from us. They're not touching their entitlement. So if they don't get any benefits from us, they still hold their 12 weeks in reserve. But in this particular absence, they're using their PTO and not benefits from us. Then what you may have maybe more frequently is they've got a couple weeks of PTO, but not enough to cover their full amount of leave, particularly when you consider that they have to hold 2 weeks in reserve. So I'm going to be out on FMLA for 3 weeks. I've got 3 weeks of PTO, but I'm holding 2 weeks in reserve under the statute. So my first week of leave, I will receive money through my PTO. So that's week 1 covered. And then weeks 2 and 3, I'll be getting benefits from CTPL. And then the fourth scenario is the employer has PTO, but it doesn't cover the full amount of the daily wages. So maybe the practice is that you pay 50% of their absence. So then they'll be receiving employer-provided PTO and Connecticut paid leave benefits at the same time. And that's when we just have to make sure that the two amount together does not exceed 100%. Right? So what we tell workers when they're trying to figure out their benefits, they need to know if their employer is going to require or permit them to use their employer-provided paid time off, and if there are any rules about how they use that paid time off. Like, can you use sick time for caregiver leave? That's some employers say yes, some employers say no. Your employees just need to know. And if the employer offers a short-term disability policy, what does that policy say? Is it the payer of last resort? Will it pay concurrently with other benefits? Okay, let me just look real quick at the questions that are coming in. What happens if an employer has unlimited PTO? So they just have whatever they need to have. If you require your employee to use that unlimited PTO, if they have a qualifying condition, then you can require them to use it. And they would not need to apply to paid leave to receive income replacement. I also have a question. Can you mandate that the PTO is used during the first 7 days of a claim? Yes, as long as the employee has the ability to hold 2 weeks in reserve. So if they only have 7 days, then you can't make them use that time because they have to be allowed to keep 2 weeks in reserve. All right. There is another question that talks about timing, which I will get to later because we're kind of intersects with the FMLA piece. So FMLA, job protected leave, right? Not income replacement, just job protection. The worker has to notify the employer that they need time away from work. And if you require them to submit an application, then they have to submit the application and provide you with the supporting documentation. If you have attendance or call-in policies that are reasonable, and you should, they have to comply with those policies. And you really want them. You really, really do want to have an attendance policy, and you really want to make sure you're enforcing compliance with those. So you should have a leave policy, and you should tell your employees what your leave policy is and if they're going to be required to use PTO, under what circumstances. If you have at least 50 employees, you're subject to federal FMLA. You have to have a federal FMLA poster. Starting in July, there is a requirement to post about the Connecticut Fmla and CTPL. It's not technically official until July, but we are putting a sample poster on our website that you can use. We recommend that you do so. As the employer, it's your responsibility to process your employees' leave requests. which means determining eligibility, validating the reason for leave with the documentation. And you'll want to monitor your employees' leave usage to make sure they're not using more time than they're entitled to, and you have to manage their return to work. And of course, refrain from discrimination or retaliation. Now, the Paid Leave Authority has no official responsibilities in connection with FMLA, but we've learned that it's really hard to train people about Connecticut paid leave and help them understand the difference between paid leave and FMLA, unless we also talk about FMLA. So that's what we're doing here. The agency with authority over the enforcement of FMLA is the Connecticut Department of Labor. And so they are the ones charged with promulgating regulations to provide more detail about how to implement FMLA. They do provide guidance to workers and employers. They have some information on their website right now, and as they update their regulations, they'll be putting more and more information on their website. And they will also investigate complaints regarding denial of FMLA, as well as claims of discrimination or retaliation. So what does this look like? Well, it starts with the worker telling the employer they need time off from work for a potentially qualifying reason. The worker doesn't have to say, hey, I need FMLA, or I would like to take job-protected time away from work under my rights pursuant to the Connecticut Family and Medical Leave Act. No one's going to say that. It might say FMLA. But basically, as long as they give you enough information for you, the employer, to reasonably infer that, this might be covered by FMLA, that starts the process. They should tell you 30 days in advance if the need for leave is foreseeable, but if the need is not foreseeable, they have to tell you as soon as practicable. You as the employer have to determine if they're eligible under Connecticut FMLA. Have they worked for you for 3 months? As well as if they're eligible for any other entitlements like federal FMLA. You have 5 business days between the time they tell you they need leave to tell them that they're eligible and to provide them with a notice of rights and responsibilities. The Federal Department of Labor has a sample notice form that you can use. Connecticut Department of Labor is working on updating a form to incorporate the Connecticut elements. This is not leave approval. This is just, yep, you're eligible, sort of the ticket to come in and maybe get the benefits. When you tell them if they're eligible, you also have to tell them if they need to provide you with any additional documentation. The employee has to provide you with that additional documentation, whether it's the med cert, the adoption records, the military records, whatever, based on the reason for leave. You have to give them at least 15 calendar days to provide that documentation. If the worker tells you, I'm really trying, but the doctor is away, I need more time, you do need to give them a reasonable amount of additional time, but they have to tell you they need it. Once you get that documentation, you review it. If it's complete and sufficient, you have 5 business days to let them know if they're approved or denied. If it's incomplete, you have to let them know what's missing and give them at least 7 days to correct that issue. When you approve it, you have to let them know if they're required to use their accruals, if they're going to need to report in, if it's their own serious health condition, are you going to require them to have a fitness for duty before they come back? If you're denying it, you need to give them a reason for the denial. If it was a foreseeable leave, and this is all done before they actually go out, they have to tell you when they're out, or maybe it's intermittent leave. So they call up and say, you approve me for intermittent FMLA for my chronic fatigue syndrome. I'm having a flare-up of my chronic fatigue syndrome. I need to take my FMLA time today. To call in and tell you that they're doing that, and they should say it's FMLA. You need to track their time because, frankly, they're job protected for 12 weeks. You want to know that they're using it, and they need to know that they're using it. And then this is all about job protection, so you need to return the worker to the job they had before they went on leave, the same job with the same terms and conditions. You can't take a first shift worker and say, hey, we found somebody better. We want to put you on third shift. You have to go back to that first shift. Just as a reminder, particularly when you're talking about someone who's out for their own serious health condition, you have to consider your obligations under the Americans with Disabilities Act and the Connecticut Fair Employment Practices Act, both of which say you have to provide reasonable accommodations to an individual with a disability to help them perform the essential functions of their job. So just a reminder about that. All right, FMLA is not easy. but it is manageable, particularly if you pay attention to the details and you're organized. So make sure you have an attendance policy and enforce it. Can't only enforce it against the FMLA people, you need to enforce it universally. But you want to know that when people are out, you want your supervisors to let your operations or HR people know when people are out. MedCerts are the crux of most FMLA claims. You want to get a complete one. Don't accept a scribble on a piece of paper. Connecticut DOL, Federal DOL, and the Paid Leave Authority all have MedCerts that you can easily adapt for your own purposes. When you have employees who are taking intermittent leave, you want to make sure that they're calling in and letting you know it's FMLA so you can track it. If you have employees who work fluctuating work weeks, usually we're talking about people who work overtime, you need to take that into consideration when you're thinking about what their work week consists of for their entitlement. But if someone can't work overtime because of their FMLA reason, then you're going to be deducting against their entitlement for that time not worked. Remember the other laws exist. Remember about FMLA. Remember about the ADA. Remember about Connecticut Fair Employment Practices Act, the Pregnancy Discrimination Act. You have to kind of hold all of them in your heads. You can't just sort of focus on one. But I do want to remind you that an employee can't say, oh, I know I'm eligible. I know it's a covered reason. Don't count it as FMLA. I want to save my 12 weeks of job protection for some other reason. If the employee qualifies and they're eligible and the reason for leave is eligible, you should designate it. This protects you from a retaliation claim or a discrimination claim or an interference claim. It protects the employee and enables you to make sure that they're getting their entitlement, but not getting more time than the law says they should. Another handy dandy chart just to make sure I've covered everything, talked about ADA, pregnancy, CFIPA, workers' comp. Obviously, a person who's got it covered on the job injury is going to be entitled to workers' comp benefits. That does encompass some elements of job protection. Primarily, it's for the benefits. A person who's receiving workers' comp benefits cannot also receive paid leave benefits. It's one or the other. Similarly, a person who's out on unemployment cannot get benefits from the Paid Leave Authority. Giving you a lot of information and it's sort of overwhelming. So I want to share some resources for you that you can access by going to our website, ctpleave.org. We have posters, we have wrap cards, we have mailers, we have fact sheets, we have toolkits. There's an employer toolkit, a small business toolkit, an HR toolkit. We actually have a whole page to sort of geared towards small businesses, but available to everybody. There's videos. There's a whole new page we launched that talks about the claim process. So we're here to help. We're here to help you understand your responsibilities and to give you the materials you need to share with your employees so you don't have to make it up. If you have questions that when you check out all that stuff, you can check out our frequently asked questions. Many of your questions are probably answered in the FAQs or in the videos. There are some videos on our website. We also have a YouTube channel. So if you look for Connecticut Paid Leave on YouTube, you can check out all of our videos and webinars. But if you still have questions, you can submit them to us through our Contact Us page on our website. So go to ctpleave.org, click on Contact Us, submit your question, and tell us, do you want a phone call back or an email back? It's incredibly expensive to maintain a call center, and our focus is on making sure that our administrative costs are as low as possible so that the majority of the money can go toward paying benefits. So we've opted to use the Contact Us portal so we can take in the questions through email and then we'll respond to you either email or a phone call. So use that. Just a quick note about that. If you submitted a question to us and you haven't gotten an answer back, check your spam folder. So we automatically acknowledge all the questions. And we do know that sometimes our emails go into spam. And then, last little PSA, go to our website, make us a favorite, check back often. We have releases pretty often, so we're updating it all the time. ctpayleave.org. That's where you go to register. That's where you can go to get information. That's the place that we just want you to remember. So I'm going to keep that on the screen so that it kind of burns into your retinas a bit while I look at the questions that have come in. So we did answer the question about unlimited PTO. If your policy is that your employees get unlimited PTO, you can require them to use it, but you do have to show that they have at least access to 2 weeks in reserve. Do have a question that came in, and it was answered while I was speaking because Amber is fabulous, and actually we had our CEO popped in for a bit. So, but let me just look at these questions for the team. Amber, I don't have a clock available to me, so if you just let me know where I am on time, so I don't.
Sure, and it's 2:58 right now, so we have a couple minutes.
Okay, great. So, question. There is in Connecticut a requirement for some employers, depending on the industry, to provide paid sick leave to their employees. Are the employees required to exhaust that paid sick leave before they can access benefits from the paid leave authority? No. Once the requirement under the paid sick leave law is that the employers provide it. Then it becomes the employer's policy as to whether or not they have to use it. And we get a lot of pregnancy questions because people who are pregnant generally tend to know when the baby's going to be born. If an employee has a baby at the end of 2021, can they still apply to receive income replacement benefits from the authority in 2022? Yes. So they have to be eligible. So they have to have that 23-25 and be currently employed or have been working the past 12 weeks. But bonding can be taken anytime up until the baby is 1 year old. So there's sort of a long kind of window where you could access the 12 weeks of benefits for bonding. We also get a lot of questions about people who have planned surgery. So say someone's got surgery planned for December 5th, and they're going to be out all of December and all of January. Well, they will, they can apply for benefits in December, but they won't get any benefits until January, and the benefits that we pay will cover the January time that they're out. We will not pay any benefits toward the time they're out in December. New question just came in. Are we required to continue an employee's healthcare coverage while out on Connecticut Fmla? Great question. If you are an employer with fewer than 50 employees, so you're not subject to federal FMLA, you're only subject to Connecticut FMLA. Connecticut FMLA says no, you are not required to maintain the employee out on healthcare while they're out on leave, but you have to put them back onto their coverage as soon as they come back. You can't make them wait an extra month. So it's up to you. If you choose to let them stay on their coverage, you can charge them. You can do benefits billing or have them pay you when they come back, but you don't have to keep them on while they're out. On the other hand, if you're subject to federal FMLA, so talking to employers with 50 or more employees, an employee who's eligible for federal leave, if you're taking federal FMLA, you do have to maintain their healthcare coverage while they're out on federal FMLA. Right. I think we're pretty much at time, if I'm right. So I would thank you all for your attention. And again, we will share the materials. You can access them through their website and check back frequently for questions. Someone just had one last question that I'll answer. If you want to go, feel free. Someone gave birth in 2021 and used up 10 weeks of leave in 2021. The question here is, are they entitled to CTP leave for a new 12 weeks? What I want to tell you is job protected leave is under Connecticut FMLA, and the Department of Labor has guidance on their website about how to handle the job protected leave part if you've got an employee who is out using Connecticut FMLA in 2021 and also need new leave in 2022. So check out the Department of Labor guidance. go to their website, ct.gov/DOL, and type in FMLA, and you can see that guidance. But for purposes of income replacement benefits, yeah, they didn't use any in 2021, so they could get the full 12 weeks of income replacement, even if they don't have job protection. All right. Oh, Amber put the guidance in the chat. Thank you, Amber. All right,
No
I'm
problem.
going
Happy to
to
help.
close the webinar. Thank you again, and I hope you all have a nice afternoon.
Great.
Bye-bye.
Thanks, Erin. Bye-bye.